Malam, Arif.
Distinguished guest speaker and fellow participants, good evening to you all. As we are about to commence our session, I kindly request everyone to settle in and ensure your connection is stable. Before we begin, I would like to remind all of the participants the ground rule for today's discussion. First, be punctual. Please join the meeting on time and ensure you remain connected during the session. Second, dress appropriately. Even though it's an online meeting, participants are encouraged to dress appropriately, maintaining a professional appearance throughout the session. Third, minimize distraction. Please find a quiet, well space for the meeting and minimize background noise and distraction. Mute notification on your device to avoid interruption. Fourth, participate actively. We invite an active participation. Please engage in the discussion, contribute your ideas, and listen attentively to others. Should you wish to contribute or pose a question, please utilize the raise hand feature or submit your inquiries through the chat box. Fifth, respect others' speaking time. To maintain order, please refrain from interrupting any speaker. All questions will be addressed during the distinct Q&A session. Sixth, use neutral language and tone. Please maintain a neutral demeanor in your language, tone, and avoid using slang or ignorant language. 7. Be mindful of camera etiquette. Keep your camera on unless there's a valid reason to turn it off. Maintain proper posture and avoid distracting movement or gesture. Furthermore, to maintain our administrative record, the link for the attendance form will be posted in the chat box shortly. We encourage all participants to complete the form to ensure your presence is officially documented. Alright, without any further ado, Om Swastiastu, Assalamualaikum warahmatullahi wabarakatuh, Shalom, Namo Buddhaya, may peace be upon us. I'm thrilled to welcome all of you to our monthly discussion on global legal affairs. This event is brought to you by the Udayana Research Center for International Law and the student community for international law from the Faculty of Law at Udayana University. I'm Krishna Pratnyaniti, and I'll be your MC for today's session. Before we proceed, let us extend our deepest gratitude and warm welcome to our distinguished guests who have graced us with their experience. Dr. Made Suksma Prijandini Devi Salain SH as the coordinator of Bachelor of Law Program Faculty of Law Udayana University. Dr. Imade Budi Arsika SH as the head of International Law Department. And our esteemed facilitator, Dr. Cokorde Istri Diah Widiantari Pratnya Dewi SH. We're here to discuss an issue of international law today with the title Corporate Liability for Modern Slavery in the Fashion Industry from the Perspective of International Labor Law. Today, the global fashion industry is worth more than $1.5 trillion and employ an estimated 72 million workers across design, production, distribution, and marketing. Yet behind massive industry lies a difficult reality. The rise of fast fashion driven by rapid production, low prices, and constantly changing trends has created intense pressure along global supply chains. As a result, many garment workers face long working hours, low wages, unsafe workplace, and in some cases, gender-based violence or child labor. These conditions are increasingly associated with what is known as modern slavery, including forced labor, debt bondage, and human trafficking. While international instruments such as United Nations Guiding Principle on Business and Human Rights and International Labor Standards highlight corporate responsibility, clear legal mechanisms to hold corporations accountable remain limited. This raises an important question. How can international labor law better address corporate liability within global fashion supply chains? To let us through this inquiry, we are joined by our speaker, Ms. Ida Ayu Dianita Maheswari, an alumni of the Faculty of Law Udayana University. Before we move further with today's event, I would like to call upon Dr. Imade Budi Arsika SHLLM as the head of the International Law Department to deliver his opening address. Time and place is yours.
Thank you very much to the MC, Ms. Krishna Pratyaniti. Am I audible? Yeah. Can you hear my voice properly, Krishna? Oh, yes. Okay.
Okay.
Good. Thank you very much. So, our distinguished professors, Professor Igustin Ngurah Parikesit Widyateja, PhD, the initiator of the UNCIL. So you have succeed to bring the UNCIL. Now is the session 7. So thank you very much. And also Ibu Dr. Choistri Diahwidiantari Pratnya Dewi. Also again to become the facilitator today. We have also the president of ACIL and the executive board of the student community for international law. Ida Ayu Dianita Maheswari. Dian, how are you today? Good? Yeah. So glad to meet you. I think today we met during the Judicium, right? 2 days ago. Congratulations for your remarkable achievement. I was assigned by the coordinator of Bachelor of Law Study Program, Dr. Made Suksma Prijani Devi Salain, to represent her in delivering the opening remarks for this academic event. So again, it is our honor to meet you again in this Zoom, because the program of international law today, the monthly discussion on global legal affairs, has already conducted several times up to now. Thank you very much for the consistency of Professor Ngurah Parikesit to organize this in coordination with the ACIL. And for the previous topics, and now the topic of the today is very interesting. And to know about the international labor law, most international legal scholars will think that, okay, this is the international organizations and it is in the field of international public international law. However, in the context of international labor law, there is one actor that play a vital role. That's we can understand how the corporations. So not only at the national, international level, but mainly at the national level. Why? Even everyone understand that in the context of the subject of international law, the MNC, multinational corporations, or TNC, transnational corporations, have increasingly become the subjects of international law, which having a limited legal personality. So the limited personality, even several scholars would classify the MNC as the very limited subject of international law in the context of the personality and legal capacity. But the Ruggie principles, the John Ruggie principles, has opened the eyes of the international society on how the corporations, in particular the transnational corporations, has a responsibility for any conduct or any activities that, for example, let's say slavery, let's say any activities that would harm the environment, for example, or the forced labor. Yeah. So any type of human rights violations. And I'm so happy because Dian, the speaker today, will talk about this issue, but on the very academic perspective. So with congratulations to Dayudian. Without further ado, allow me to open the UNCIL International Law Today, panel discussions on global legal affairs, session 7 on the topic of corporate liability for modern slavery in the fashion industry from the perspective of international labor law. I hope all the participants will enjoy the presentation and discussions today. Thank you very much.
Thank you very much, Mr. Budi Arsika, for the wonderful remark as well. And the moment you've all waiting for, all distinguished participants, I'm excited to introduce our speaker, Ms. Ida Ayu Dianita Maheswari, an alumni of Faculty of Law, Faculty Udayana University. Her research is looking for a way to retrieve a middle of justice. It explores how international labor law can be adapted to ensure that if a company profits from a global supply chain, it must also be held legally responsible for the safety and dignity of every worker within that chain. Also, to help us navigate our discussion, please welcome our facilitator, Dr. Cokordo Istri Diah Widiantari Pratnya Dewi SH.MH. To Ibu Cok Diah, the time is yours.
Thank you very much for Krishna, the MC for today. Thank you. First, of course, good evening. The Honorable Head of Bachelor of Law program on this occasion, represented by our Head of International Law Department, Bapak Dr. Imade Budi Arsika SHLLM, and also our initiator of UNCIL, Professor Igusti Ngurah Parikesit, a PhD. Thank you very much for the initiator, so we can be here today for another discussion about international law, and also for SEAL and all participants who gather today via our Zoom meeting. Thank you very much. And of course, today our speaker, Ida Ayu Dianita Maheswari, SH. She obtained her Bachelor Law of degree from Faculty of Law Udayana University, and during her studies, she was actively involved in various students' organizations in Faculty of Law Udayana University. Dayu, or we usually called her Dian or Dayu, will deliver her presentation about corporate liability for modern slavery in the fashion industry from the perspective of international labor law. So, despite its global success, the industry often linked to many issues, especially serious human rights issues, particularly forced labor and exploitation within supply chain. From international law perspective, an important questions arises. Since international law traditionally binds states, how can corporations be held accountable for these violations, and how international labor law manages these issues? So, should corporation be directly liable under international law, or should responsibility remain primarily with states? So, without further ado, I would like to invite Dayu to deliver her presentation. So, Dayu Dian, time is yours.
Thank you to Ibu Dr. Cokorda Istridiah Widiantari Ratnadewi SHMH as the facilitator for introducing me. Om Swastiastu, Assalamualaikum warahmatullahi wabarakatuh. Shalom Nama Budaya, may peace be upon us all. Good evening, the Honorable Coordinator of Bachelor of Law Program, Ibu Dr. Made Suksma Prijandini Devisa Lain SHMH LLM, and Head of International Law Department, Bapak Dr. Imade Budi Arsike, SHLLM, distinguished lecturers, Prof. Parikesit, and all the participants for today's webinar. First, of course, I would like to thank all distinguished lecturers from the International Law Department for facilitating this webinar, and also SEIL for facilitating this webinar. I'm Ida Ayudanita Maheswari, and before that, I would like to share my screen first. So let me share my screen first. Is it visible?
Yeah.
Okay.
Yes, it's visible and clear.
Okay, thank you. Let me start. I will present my research, which entitled Corporate Liability in Modern Slavery Within the Fashion Industry and International Labor Law Perspective. So, the fashion industry itself is a global sector which valued at approximately 1.53 trillion US dollars, with complex cross-border supply chains. And the dominance of fast fashion, as we all know right now, like maybe all the participants here know fast fashion brands like H&M and then Bershka or whatsoever that we all know, has increased the demand for demands and then for rapid and low cost production, of course, which in turn drives the need for cheap labor, particularly in developing countries, including Indonesia. And as the result, the system often leads to human rights violations, including practices of modern slavery within the supply chain itself. And however, there remains a normative gap, as there is no specific or explicit regulation governing the corporate liability for modern slavery itself. And this gap results in weak supervision, difficulties in proving violations, and inadequate protection of the laborers or workers itself. And then, based on the background, this research addresses two main questions. First, how does international labor law regulate corporate liability for modern slavery in the fashion industry? And what are the legal implications of corporate liability for modern slavery in the fashion industry from the perspective of international labor law? And then this research is based on three main theoretical frameworks. The first one is the legal certainty theory, which in the context of this research itself, the normative gap that is previously mentioned on the background leads to weak enforcement and inadequate protection of the workers or the laborers in the fashion industry. And then the second theory, which is the human rights theory, which recognizes that human rights are inherent, universal, and must be respected without any discrimination. Therefore, modern slavery in the fashion industry itself constitutes a serious violation of human rights. And then the last one, the third one, the strict liability theory, which allows corporations to be held liable without the need to prove fault. as long as there is a causal relationship between the corporation's activities and the resulting harm, which this is particularly relevant for the supply chain context in the fashion industry. And then moving on to the next slide. So this research itself is employs normative legal research, as seen on the screen. And then moving on to the general overview of the fashion industry itself. So the fashion industry is a global sector that involves design, production, and distribution of clothing. So whatever that we wear right now, this second, from head to toe, is from the fashion industry. So it has a very complex organizational structure, and it's not the same for every corporations, of course, since it's a private company. So it's ranging, but mostly it's ranging from the top management to the workers or the laborers at the operational level. And then there's the industry also includes various sectors, such as the textile and design and production, the fashion design and manufacturing, which is the scope which that we're going to focus on right now. And then there's fashion retailing, marketing and merchandising, and then fashion shows and media. And then moving on to the corporate liability. Corporate liability refers to the legal responsibility of corporation for harm that caused by the activity of the corporation itself, and which encompasses civil liability, criminal liability, and other forms such as environmental and product liability. But on this topic itself, we'll be focusing on the civil liability and criminal liability. And then from the traditional perspective, corporations are responsible because they have control over their employees or laborers or workers. And then we can see from the economical perspective, the corporations are best positioned to prevent harm through supervision and regulation. And then we're going to move on to the modern slavery. So modern slavery, as for now, is an umbrella term which includes various forms of exploitations, such as forced labor, human trafficking, forced marriage, exploitation of children. Although, as for now, it's widely recognized, but it does not yet have a fixed definition in international law, especially in international labor standards. So, and then there are some forms of the modern slavery itself, as we can see on the screen. There's forced labor, there's like a lot of other form like categorizing that we can categorize as forced labor, and then forced marriage, which always or usually results in further like exploitation, like sexual exploitation, severe restriction on personal freedom, even identity documents, and then exploitations of children works in like fashion industries that often carried out through child grooming. And then we're gonna move on to which is the regulations of corporate liability. At the international level, the regulation on corporate liability, we can say it's pretty indirect. So there are some so first one, the ILO instruments protects fundamental labor rights, and then the UNGP or UN Guiding Principles on Business and Human Rights emphasize due diligence and corporate responsibility. And then the OECD guidelines, it's much more of a like providing some standards or like voluntary standards. But however, all of these are mostly soft laws, or they are not legally binding. So and now we're going to move on to the Indonesian law, which before that, many countries recognize corporate liability, of course, but for example, in Indonesia, recognize corporations as criminal subjects with clear liability under the new criminal code, but civil liability, as for now, in terms of corporate, still remains unregulated. And then we're going to move on to the other countries that also regulates the corporate liability. In Italy, there is the legislative decree number 231/2001, which the corporations are subject to administrative liability with fines paid from their own assets rather than direct civil liability. And then in Pakistan, the Companies Act 2017, corporate liability is based on a separate legal personality, although directors may still be held personally liable for like misconduct with significant legal penalties. And then in Bangladesh, corporations can be held liable under both civil and criminal law, including labor and environmental regulations. And overall, all of these shows that corporate liability is recognized. Its regulation varies across jurisdictions. And now we're gonna move on to the modern slavery regulation. As for now, in international law, as we all know from the research question before, there is no comprehensive international regulation on modern slavery as for now. And the existing rules only cover certain aspects through the international labor standards and all of the all of these, like the Forced Labor Convention, the Protocol, Discrimination Convention, Minimum Age Convention, Worst Forms of Child Labor Convention, Hours of Work Industry Convention, Reductions of Hours of Work, Textiles Convention, Workers with Family Responsibilities Convention, and so on. So, and then we're gonna move on to the to Indonesia. Currently, Indonesia does not have a specific legal framework regulating the modern slavery. But however, several provisions in the national labor law, as we all know, the law number 13 of 2003 on manpower, serve as preventive measures. These includes the right to non-discriminations, equal treatments, fair wages, as well as protections against child labor, unsafe working conditions, and excessive working hours. The law itself also guarantees workers' rights to rest, occupational safety and health, and decent income. Overall, these provisions provide important safeguards, while these provisions provide they remain indirect and do not comprehensively address modern slavery. And then we're gonna move on to the other countries. So there are a few countries who recognize the modern slavery and already adopted a specific law of modern slavery. So the first one is in the UK. There's Modern Slavery Act 2015, which regulates and consolidates offenses of slavery, forced labor, and human trafficking, and requires supply chain transparency for large companies. And then there's also in Australia, there's the Modern Slavery Act 2018, which includes like the operations and supply chains or like corporations should have a statement that includes assessment of modern slavery risk and operations and supply chains along with mitigation measures that they're gonna do if that happens. And then these laws, as we all can see, requires transparency and a report from the corporations themselves, and a little analysis on all of these materials, especially the regulations part, since there is a normative gap that, as we all know, in the international labor law because modern slavery is not yet comprehensively regulated and lacks a unified definition and enforcement mechanism. And this gap leads to inconsistencies in the national laws um, in in other countries, and then which highlights the need for a more responsive and binding international legal framework. And then we're gonna move on to the implications itself because of the legal gap and so on from the labor perspective. So from the labor perspective, the normative gap, of course, has significant consequences. So the first one is implications for sanctions and deterrence, which sanctions imposed on corporations are often limited to fines or just administrative penalties, which fail to create a deterrent effect to the corporations itself, which in which the example is the Loro Piana case, which happened recently last year in 2025. So this case, the Loro Piana case in Italy, illustrates exploitative subcontracting practices. And then the second one, the implications for victim protection and remedies. So for this, the second one, the second implication, victim protection still remains weak as legal system tend to prioritize sanctions over effective remedies. And so similarly from the first case, the Loro Piana case, there's the Rana Plaza disaster that going on in Bangladesh on 2013, that which resulted in over 1,000 deaths, demonstrates the severe consequences of inadequate regulations. And then we're gonna move on to the corporate perspective or the corporation's perspective. So there are three implications for the corporate itself. So the first one is financial losses. The companies may face financial losses due to declining share value and legal costs. And also, the second one, they also may suffer reputational damage, particularly due to social media exposure as for nowadays. And as we Gen Zs who usually love to like do boycotts on certain brands. And then in addition, companies also may experience operational disruptions when forced to restructure their supply chain. So the examples for these all of these implications, there's Boohoo, it's similar to Laura, if you all may know. And then there's also from Zara Brazil in 2011 and 2015, and then there's H&M in 2017. And then we're going to move on to the next one, which is the efforts to fill in the normative gap as in now. So the efforts to address the normative gap involves both international and national actors, of course. So the ILO plays a role in promoting labor standards and decent work through the SDG 8, as we all know, which is this decent work and economic growth, which has four main pillars of the so the SDG 8 has four main pillars, as we can see on the screen. And then also but there's like soft law instruments such as the UNGPs and OECD guidelines encourages responsible business conduct and due diligence. However, these instruments are not really legally binding, and their effectiveness depends on the national implementation and also, of course, from the corporations themselves. And then we're gonna move on to the next slide. From the human rights perspective, so from the human rights perspective, modern slavery violates fundamental rights, including the right to freedom, dignity, and fair working conditions. And corporate liability is pretty much essential because corporations have significant economic power and influence over the workers or laborers' lives. And then however, victims often face barriers in accessing justice, including high costs, evidentiary challenges, and jurisdictional issues. Therefore, stronger legal mechanism, mandatory due diligence, and effective remedies are pretty much necessary. And then we're gonna move on to the next slide. So, what is the importance of corporate liability in the fashion industry from the human rights perspective? As we can see, there are 6 points. The first one is, the multinational corporations possess substantial economic power, as we all know, with significant impacts on human life, which rendering their accountability for human rights violation essential. And then the second one is the gap between practice and the consequences. In practice, many corporations, particularly in the global fashion industry, face only minimal administrative sanctions for human rights violations, while victims encounter significant barriers in obtaining effective remedies. And then the fashion industry specific factors. So this industry is outsourcing model to low-wage jurisdictions with weak legal protection, with competitive pressures that depress labor standards, with corporations often deflecting responsibility onto suppliers despite contributing to exploitative conditions. And then, of course, we are in need for legal mechanism, which binds regulation and accountability mechanism in criminal, civil, or even administrative are required to ensure that corporations causing or contributing to human rights violations are held responsible. And then UNGP and the right to remedy. Corporations are expected to participate in victim remediation. However, despite the importance of effective remedies, victims face barriers such as litigation costs, evidentiary challenges, limited access to information, and jurisdictional constraints. And then the key measures, the implementation of human rights due diligence, effective access to remedies, and robust legal sanctions are essential to prevent ongoing human rights violation in the global fashion industry without accountability. And move on to the conclusion slide. So, in conclusion, the corporate liability for modern slavery in the fashion industry is indirectly regulated through international instruments such as the International Labor Standards, the UDHR, and the UNGPs, with a focus on due diligence, corporate social responsibility, and state oversight. However, the dominance of soft law results in weak legal certainty and sanctions, leading to inadequate worker protection. Therefore, stronger international regulation, harmonization of national laws, and enhanced state involvement are required to ensure the corporate's accountability. And then there's also recommendations. The ILO and the United Nations should promote the development of binding legal instruments regulating modern slavery and corporate responsibility in global supply chains, including mandatory human rights due diligence and the harmonization of labor, human rights, and international business laws. And then the states must strengthen oversight, evidentiary mechanism, and sanction, which is administrative, civil, and criminal, to ensure deterrence while also guaranteeing effective human rights-based remedies and recovery for the victims themselves. And that's all for my presentation on my research. Thank you for your attention, and I'll give the time and place back to Ibu Chodia as the moderator. Thank you.
Thank you very much, Delegate, for very refreshing and insightful presentations, even though it's about modern slavery, but you did it very well. You deliver very well, and thank you very much. And before we moving to the questions and answers, I would like to greet one of my fellow lecturer from Universitas Parahyangan join this discussion. Thank you very much for Miss Anna Anandita. Thank you very much for joining us. Hopefully you will have great time. And of course, I would like to ask our Honorable Professor Parikesit, maybe he will give response because he's the first advisor from this a researcher. So from this research, so maybe there are any response from Professor Parikesit. Time is yours, Professor.
Okay, thank you so much, Ibu Cho, for the time and opportunity. All distinguished guests and Pak Budi, Ibu Cho Dia, colleagues from University of Parahyangan, SAL as the organizing committee, all the students that have participated in this occasion, and for Idayu Dianita Maheswari. Yeah, it is my honor, yeah, to have a chance to supervise Dayu during this time. But before explaining about some substantial issues, I just want to give my sincere appreciation for you, Dayu, because I know tomorrow you are going to have graduation. Yeah, 2 days ago you were in Lyceum, and then tomorrow you are going to be very officially. You are already official as graduates, but tomorrow is the final day. Yeah, the final party for the graduation. Yeah, so I can imagine what is your feeling now. Yeah, prepare for tomorrow and then still preparing for the presentation. So it's not easy. Yeah, even if you are familiar or fluency in English. Yeah, thank you again. And yeah, today's dialogue, when I first read this material, this paper, then I realized something is still left about the fashion industry. Yeah, the fashion industry is one of the most progressive, the most advanced industry, because they have very big market, not just in the developed countries, but also in the developing countries. Yeah, you can name all the top brand, like, yeah, we can say like Louis Vuitton, like Gucci, like Dior, or I like sometimes because the price is affordable, like H&M or Uniqlo. Yeah, because I will not spend much money to buy luxurious thing, but H&M and Uniqlo. This is a promotion. It's just example how the fashion industry is growing so fast recently, because of also influence from digitalization, influence from the influencer, influence from all the public figure. It create the fashion industry is very, very advanced. But behind that phenomenon, behind that fact, we didn't realize if there is a trend of, yeah, at the first I didn't call it as a modern slavery, but I think this is more and less about exploitation of work, like how they have to work overtime but less paid, yeah, or how then the company usually provide or put a children as a workers, yeah. And when I read this research and then realized that some countries like UK or Australia then explicitly stated modern slavery act, then realized, oh, this is something, it's very interesting because maybe, yeah, not just in China or in US, maybe in our surrounding in Indonesia, for example, we will have the same problem. We have so many also garment industry. Yeah, we rely on the garment industry, for example, as a part of manufacturer companies because they will employ many people. Yeah, employ many people, then will help the government to reduce unemployment rate. Yeah, so the government very light. But again, yeah, uh, if Indonesia has not yet regulated modern slavery, especially in the fashion industry, then uh, from this research, I then realized that, oh, even in international level, from the ILO convention, for example, from the UNGP, yeah, Universal Guiding Principle, Business and Human Rights, and from OECD, yeah, they don't really uh, have a fixed regulated to prevent or to minimize the negative impact of modern slavery. Yeah, as that you said, yeah, there is a rules, there is a convention or agreement on that, but yeah, there are maybe soft law and the national government, especially in developing countries, yeah, really careful to put them into a regulation because especially in developing countries, they fight for growth economic. Growth economic meaning that many job creation. Yeah, that's why we have job creation law. Yeah, with some controversies. Uh, and if then employment issue is strictly regulated, it will contradict, yeah, with the goal for sustainable or stable economy. So this is like a dilemma. Yeah, that's why from this research, then we need to be aware, yeah, not just because of the issue in paper, but because in the upcoming years when the situation is getting hard because of the war, because of the decrease of economic, because of high geopolitical tension currently, then yeah, and then the population never stop. Yeah, the population of people across the globe always increasing, and there will be any situation where, yeah, where the number of population that need a job will always increase, but the job itself, yeah, will not be enough to cover, to adapt, to create workers as expected. So the situation will be difficult because yeah, the investor, the company will have like higher position, higher bargaining position, yeah, for the workers. Yeah. If you don't want, if you don't accept this offer, then yeah, I will choose another worker. Yeah, I just have this money to pay for you, and if you don't like, then you can, yeah, you can leave, you can find another company to get. So this is a kind of like a dilemma that need to be addressed in the future. And thank you again for Dayudian. Yeah, I know her maybe since she was little or since she was junior high school, and then now I'm so proud to see how you are growing, and I hope all the participants joining tonight will have any knowledge, will inspire, and will have or will provide uh, better research on the future. Okay, I think that's all from me. I will like to give the time for Ibu Cho.
Thank you, Prof. Parikesit, for your response and your insight. And now we're moving to the discussion, question and answer. I hope there will be many questions from the participants because it's an interesting topic, and we are quite familiar with the fashion industry, fast fashion, and also for the human rights issues in this matter. So maybe for the first batch, 3 questions. So for anyone who wants to ask, you may raise your hand and also open your camera and microphone. So go ahead. Participant, don't be afraid to ask questions. Don't be shy.
I saw Pak Dr. Bayu from Wigendra University also attend this meeting.
Thank you
And
very much.
maybe Dr. the Bagus Bayu will have any question to Dayu Dian.
Participant, I think it's a interesting topic. So there will be many questions about this topic. So you freely ask whatever regarding to this topic. Come on, participant. Don't be shy. Bapak Bayu, welcome to our discussion session. Thank you very much for joining. For participants, maybe you can raise your hand and open your camera and microphone. So ask question for speaker. Okay. So maybe I will. May I have question for the Yudian, Prof. Parikesit?
Yes, yes,
Okay.
you can.
While waiting for the questions from participant, maybe because I am not one of the examiner from the Yudian, so this occasion I will ask about. So it's quite close with human rights issue, and we know that Indonesia is one of the country that have, I mean, like there are many factory from the brand, like we have Adidas, we have any kind of brand, and you know that the production cost is so low, but they sell so high. So but the workers not get much paid. So how the law or the corporation, how the regulations to maintain or manage the situation? Can Dayu give me insight about that? Thank you very much, Dayu.
Okay, thank you for the question, Ibu Chodia. So maybe I'll answer it from the regulations in Indonesia, especially specifically. So as we all know before, from the slide, let me maybe just go back to the slides. So maybe as for now in Indonesia itself, there are because the topic or like the example that Adidas um is in Indonesia. So maybe for now Indonesia only has like preventions law, like several provisions that can serve as the prevention, as we can see on the law number 13 of 2003 on manpower. There are and about like payments or wages for the laborers itself themselves, sorry. There it's specifically mentioned in the Article 88, which ensures the right to decent incomes, with the government setting wages, wage policies, including minimum wage and other components. Maybe as for now, that's the prevention, but there's no like specific like um must or a, how can I say it, a like something that's saying that you must have this uh on your corporations and from the government, but maybe from the corporations have like some regulations on their wages, so they can treat the laborers fairly and give the right wage. Maybe that's the answer.
Okay. Okay, thank you very much. Also, there is no regulations if the how much the cost, the production cost, it the and how they sell the products. It could be 100 times than the production cost. So there is no regulations about the limitation of that. During your research, do you find the regulation about that? So how much the uh, corporation could arise the cost when they want to sell from the production cost? Is there any regulation about that, or they don't regulate it?
Okay, thank you so much for the follow-up question, Ibu Choria. So as far as I know and as far as I research, and it's before that, it's a new insight for me that I should have like put that also in my research, and I should have searched that beforehand. But as far as I know and research, then there are no specific regulations, but as far as I know, that the prices from the brands itself, it depends on the brand reputations themselves. So that's why corporations uh that's why it's important for corporations to like acknowledge that uh they don't want to do the modern slavery things, so they could still have their reputation and still sell for the brands themselves. Maybe that's my answer for that. Thank you.
Thank you very much, Dayu. So, participants, I'm still waiting for your questions for Dayu. I think there are many questions after all. Don't be shy. Don't be shy to all participants. Raise your hands and ask the questions. Come on.
Okay, while waiting for the participant, I would like to this is not a question, but because some of the students who participates tonight are in my class of international law course, and then they learn about international legal subject, and yeah, learning about the full and limited capacity, and how they have to have like legal personality and etc. And can you make us analysis, Dayudian, about the position of multinational corporation? Is it qualified as international legal subject, legal subject in international law? I mean, what do you think? Yeah, from this case, yeah, yeah. Mm.
Okay, thank you for the question, Prof. Parikesit. So in my opinion, based on the questions itself, I don't think the corporations is a like legal personality as a whole, but it's a limited legal personality because they are not states overall. They are a private sector, and they have their own like rules and stuff. So I don't think they are the a legal personality as a whole and full, but they are very limited. Yeah, I think that's my answer for that.
Yeah, 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 and yeah, yeah. You're right. Yeah, you're right. And you are, what I can add is just like, yeah, if then multinational corporation or transnational corporation can be accountable, can be responsible. Yeah, if there is a regulation or rules that require every company, yeah, multinational company, for example, yeah, must be registered, must be registered under national law. For example, we have limited liability company law, yeah, number 40 2007, require that all foreign investor when they want to do a business, then they have to have formal registration process under Indonesian law, or transnational corporation when they have a brand office in Indonesia. Yeah, they also have to follow or to register in Indonesian law. So if they do something wrong, yeah, then Indonesian law will be applicable to prosecute them. That's the strategy that we can do for prevent or for uh, giving any legal consequences for company in Indonesia particularly. But in international, yeah, because in international level, so as you mentioned before, yeah, there is no any explicit or strict rule to 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 classify or to punish the actor of modern slavery. Okay.
Okay. Thank you for.
There is a question from.
Is it need a response from
No
Dayu?
need.
Oh no. Okay. Thank you very much, Prof. Parikesit. And there is one question from Bapak Dr. Ida Bagus Bayu Bramantia SIMH in chat box. So, from the perspective of international labor law, what specific legal reforms would you recommend for garments producing countries like Indonesia to more effectively combat modern slavery in the fashion sector? So, if Dayu ready to answer, you may answer the questions. Thank you very much for Bapak Gus Bayu for the question.
Okay, for that, thank you for the question, Bapak Dr. Ida Bagus Bayu Brahmantia SHMH. So, let me repeat the question. So from the perspective of international labor law, what specific legal reforms would you recommend for garment producing countries like Indonesia to more effectively combat modern slavery in the fashion sector? Before that, so Indonesia hasn't really like have a specific regulations on like modern slavery. Indonesia, we can say that Indonesia doesn't acknowledge modern slavery as for now. So I think the from my opinion, I think maybe as for now the specific legal reforms would be like enhancing what we have, as in like in the law 13 of 2003 on manpower. So the specific law itself, it's pretty much for all the sectors and that has laborers and workers. So I think in my opinion, I think to more effective, as for now, the first thing that Indonesia needs to do, of course, to acknowledge what is modern slavery and also be more open to us like modern slavery, of course, because as we all know, and from the question itself, Indonesia is one of the like garment producing countries in Indonesia. So like or the like the substance in modern slavery is not yet known in Indonesia. So I don't think for now Indonesia has like that we can do, all we can do for now is prevent, but if the specific legal reforms, maybe there can be like more there can be like more rules or like law on like improving that what we have from the law number 13 of 2003 on manpower. Maybe like more specific laws like sanctions or like deterrence and all sorts of that. I hope that answers your question.
Thank you very much, Dayu, for the answer and for Bapak Ide Bagus Bayu. Apakah is there any response for the answer or any follow-up question?
Thank you very much, Ibu Cokorda Istri Dia. This is very, very interesting topics. I would like to say good evening to Prof. Sigit. Thank you very much for guiding this important discussion tonight. Yeah. And of course, to dear Dayudian, have a wonderful presentation before. So I would like to say thank you very much for the answer and for your wonderful and inspiring presentation on corporate liability for modern slavery in the fashion industry for the perspective of international labor law. I really learned a lot and felt very motivated by your explanation. Thank you very much, Dayudian. Thank you very much, Prof. Sigit, and thank you very much, Ibu Cokorda Istri Dia Widya. See you on Fakultas Hukum UNUD. Thank you.
Thank you. Thank you very much. Okay. So is there any other questions from the participants? We're still waiting. We still how many times left? We still have many time, right?
Yeah, you're right. Yeah, at least at 9 p.m. We still
Okay.
have time to 9 p.m. if many questions arise in this session.
Okay, participants, you still have time to discuss this topic. Questions for Dayudian. You may use this opportunity to discuss about international law, about labor law, and maybe human rights issues. Participants, we're still waiting. I guess there are students from my class in international law. Maybe you may use this opportunity to ask question. Okay, anyone? So, Dayudian, we know that the regulations about this are mostly soft law. So, internationally, it regulated by soft law. Do you think soft law is enough to regulate this issue, or maybe in future you want something more powerful to regulate this? So, how your argumentation about the regulation?
Okay, thank you for the question, Ibu Chodia. Soft law, yes, it's not really binding. I think, from my opinion, I think it's a must that in the future, there will be like a more binding regulation on modern slavery because I think as for now, modern slavery is a very, very new topic to discuss about. There's not much. And a little fun fact while doing this research, there's not much resources that I can say in researching on research while I'm researching this topic, especially on the modern slavery part, because there's a lot of things that are really known, and many countries have regulated and have a lot of like laws for that. But for modern slavery itself, many countries didn't really recognize that in their own countries they have like the modern slavery there. Like they don't really realize it's a form of modern slavery. So I think the acknowledgement of modern slavery now and in the future is very, very important. And yes, it does need a more legally binding um, law. But as we all know, the soft law is not really legally binding. So maybe for now, I think it should start small from the corporation themselves, that they need to acknowledge that there's modern slavery, and then you don't want to do that to your workers, because the workers is like the core of your corporations, of your economy, on your corporations themselves. So I think the small thing, it's not really small, but I think the first thing that that we need to like do and improve for now, I think it's the recognition from the corporations for the modern slavery itself, and also the states to acknowledge that there is modern slavery for now, not just the regular traditional slavery. Yeah. So future, I hope there will be a specific regulation like in Australia and in the UK, and from the laws that have been regulated itself in the UK and Australia, it's very, very interesting and very, very specific. I think they even like put like the revenue requires like the in Australia they even put like the annual revenue. So it's a must regulation for them. So I think in the future, especially maybe in Indonesia for now, it's a very, very important thing to acknowledge modern slavery first, and then to hopefully regulate it next. Maybe that's all for my answer. Thank you.
Thank you, Dayu. And for Indonesia itself, our regulation, we didn't regulate it about modern slavery yet, if I'm not mistaken. So, in what your opinion, which regulations much suit better to Indonesia, UK or Australia? From what your perspective, your research, so which regulation suit better for Indonesia? Which one you prefer for Indonesia?
Okay. Thank you for the question, Ibu Chodia. I think as for now, I don't want to be biased, like only one, but from my opinion, I think it should be like it should like take inspiration. If Indonesia will make a regulation about the modern slavery, it should take like inspirations from the UK and the Australia, of course, because these two acts that I researched back then, they have pretty much the same contents, but in Australia themselves, it's that's why I put it here, and it's a very, very interesting article on this act itself. They like include the revenue of the entity itself, so I think that's a very, very important thing to mention. If they make if in the future there will be like the regulation in Indonesia, because I don't think corporations will know that they are considered a big corporations. Is it important for them to like um how can I say it? Is it important for them to like follow the rules or the law? I think so I think in the future Indonesia should take inspirations from both.
Both.
Yes.
Okay. Thank you very much. I'm sorry for very exit. But thank you. I learned a lot from this discussion because it's a new topic from me. For me, new topic for me. Thank you very much, Dayu. You give me very wonderful insight about this modern slavery. Thank you very much, and my greetings for your father. Thank you. Thank you very, very much. And now moving back to the participants. Don't make me this is my my only only me who discuss with Dayu. So I hope maybe one question from participant again. Don't be shy. I will not mention your name, so you voluntary ask question for Dayu from the regulations or human rights or modern slavery, maybe new topic for you. So you may ask questions for Dayu. Participant, I'm still waiting. Students from the Prof. Parikasit class maybe ask question, and student from my class. Participants. Simple question for Dayu, maybe in bahasa Indonesia you can ask question. Use this opportunity. If you're too shy to open your camera, you may write down on chat box your question. Participant.
Yeah, maybe we, if there is no more question, and then, yeah, we may stop earlier, letting Dayu to prepare to choose what kind of fashion or outfit for tomorrow.
Okay. So if there's no other questions, so our discussion today. So thank you very much for everyone who joined this discussion, and I did very insightful discussion today. So we can see that corporate liability for modern slavery in fashion industry remains a complex uh, especially from international law perspective. While there have been important development challenges in enforcement and accountability still exists. States are really responsible but are expected to regulate corporate conduct. Corporate liability for modern slavery in fashion evolving from soft responsibility and but legal accountability. So not only uh, not only about regulation but also about strong commitment from states, corporation, international organization, in this case ILO, and also from society. So I hope this discussion can help us better understand the legal and ethical dimension of the issue, as well as the role of both states and corporation, and also about human rights in international labor law. And thank you very much. And I hope we can see each other again in another discussion about international law. And thank you for Professor Parikesit, for the initiator, and for Pak Budi, and also for Dayu, who delivered the presentation very well. And congratulations for tomorrow graduation. And for all participants, thank you very much. For SCL, thank you very much. And I give back time to MC. Thank you.
Thank you to Ibu Chodia, Miss Dayu Dianita, distinguished guests, and all participants for the awesome discussion session. We really appreciate your dedication to make this dialogue more meaningful. Before we proceed to the closing of today's session, we kindly ask all participants to fill out the final attendance link that will be shared in the chat box. Now, I would like to invite all participants to turn the cameras on as we begin the documentation session. Starting 1, 2, 3. Once more. 3, 2, 1. Thank you. As we conclude today's session, I would like to express my sincere gratitude to everyone for your valuable contribution to today's discussion. Please ensure you complete the attendance form to obtain the certificate. On behalf of the organizing committee, thank you for your active participation. We look forward to seeing you again at our future event. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom. Namo Buddhaya. May peace be upon us.
Baik, terima kasih banyak.